Quickly after we heard the news, protesters began taking to the steps of the Supreme Court to show their opposition to the real possibility that the landmark Roe v. Wade opinion will be overturned. Planned Parenthood also issued a statement saying it's outrageous, it's unprecedented, but it is not final. Abortion is your right, and it is still legal. It is important, of course, to get legal context when we have big issues like this. And so today we have brought in Seema Mohapatra, who is a health law expert at SMU Dedman School of Law. Thank you so much for being with us today. Really appreciate it. We know that this is quite the thing to talk about today as far as your profession goes. I'd like to ask you first here if you could talk to us about the legal fallout that could occur here if, in fact, Roe versus Wade is overturned, specifically in places like Texas.
So Texas is one of many states that has a trigger law. So once Roe v. Wade is overturned, abortion access would immediately become illegal and criminalized in Texas. And a lot of the neighboring states of Texas also have these trigger laws. And so that means that people that are seeking abortion care would really not have access to it in Texas or in neighboring states, which really impacts who is able to get that kind of care.
And it's important to underscore here too, isn't it, that when Texas passed the very restrictive abortion law last year, that was a law that was enforced civilly. It was enforced through people filing lawsuits, and so we saw some people, some providers challenging that law and going ahead with procedures. If, in fact, Roe v. Wade is overturned and trigger laws kick in, that could mean that we would start seeing criminal penalties here in the state of Texas rather than just lawsuits. That's a very different environment.
Absolutely. And so there's not going to be any kind of restrictions against criminalizing abortion providers and even people that are seeking abortion, which would be a totally different landscape. Essentially, in Texas, since SB 8 passed, access to abortion care in Texas has been very limited, but it hasn't been under the threat of criminal prosecution, which is what could happen if Roe v. Wade is overturned, as it seems like it's going to be from the leaked opinion.
Let me ask you about the leak of that draft opinion. This really is a seismic event for the Supreme Court. Usually they traditionally conduct these sorts of exercises. Everything's cloaked in secrecy. The rest of us don't hear about it until they officially make their rulings public. How does this affect the High Court now that this draft has been made public to the world?
Yeah, I think there's going to be kind of panic and an investigation on who leaked this, what their purpose was, why it's being leaked now. If this draft was dated a couple of months ago, what's the purpose of it being leaked now? Is it because Roberts has a concurrence right now, or if there's some dissenting opinions and there's some concern about who's going to stay wed to this majority opinion? And so there is going to be an investigation, and there's probably a lot of paranoia about the kind of security of these, important decisions that is occurring. However, it is kind of a distraction compared to the fact that this is a huge shift in our jurisprudence and kind of taking away some of the focus on that and focusing on the leak instead of focusing on the fact that pregnant people will not have access to abortion care in many states, including Texas.
There's been a lot of chatter here about, if something as landmark as Roe v. Wade can fall and be overruled, that really opens up the possibilities that we might see this happen with other things. This draft opinion, of course, only about abortion, but a lot of people are worried that this might also set up new threats to other contentious issues like contraception and gay marriage. Have you been hearing about a lot of that in the legal community, in the law community?
Absolutely. When you read this opinion, it's written very broadly, and part of Alito's decision-making is because abortion was not in the history and tradition of this country. But if we look at that kind of language and the fact that abortion is not in the Constitution, there's nothing about gay marriage or marriage equality in the Constitution. There's nothing about contraception. There's nothing about, desegregated public school education. There could be a lot of different things that are impacted that you might not actually connect to this. However, this is a broadly written opinion that really weakens a lot of the substantive due process rights that Americans have relied on for many years.
I think a lot of people are going to be watching very closely how all this plays out when we do get a final opinion sometime. We're expecting, I guess, in the next month and a half or so. Seema Mohapatra, again, thank you so much for being with us, health law expert at SMU Dedman School of Law. I know that your phone has probably been ringing a lot today.
Thank you so much for having me.
Thank you. A quick reminder here, the Supreme Court has already ruled on Texas law, which bans abortion after a fetal heartbeat is detected. Here's what the 9 justices said about Texas Senate Bill 8. The court voted 5-4 to keep that law intact. They also voted almost unanimously to allow lawsuits against it to continue, with Justice Clarence Thomas as the lone dissenting vote on that part of it. Be sure to stay with WFAA for updates on this story, because it does just keep evolving. You can check WFAA.com, or of course download our WFAA app and sign up for those push alerts so that we can notify you as soon as there is a development. As always, that app is free in your app store.